So now that we're all in the same room together, welcome, of course, to the Moot Court Virtual Showcase, and congratulations to the Grandview Heights High School Moot Court team. We're so glad that you could be here, and we're very much looking forward to seeing all your hard work pay off today. So thank you, and thank you also to the judges for lending your time and expertise to evaluating and interacting with Laura and Sally today. We very much appreciate your time too. So before we dive in, I did want to just give a few reminders, and I'm sure that we have all had a lot of chances to get acquainted with Zoom etiquette over the past few weeks, but just a few reminders to mute your cell phone and to turn off computer notifications so we don't have things pinging during the arguments. And also, if you're not speaking, just go ahead and mute your microphone. So looks like Brian has started the recording already. And then before we begin, the last thing I want to do is to give a quick overview of the process for the round. So we'll begin by having the judges introduce themselves, and we'll start off with the Chief Justice and then go down the line from there. And then I'd like the students to introduce themselves and their teacher as well. And then the Chief Justice is going to begin arguments by inviting the first student for the respondent to give a 7.5-minute argument. And just a reminder that judges may interrupt at any time to ask the student advocates a question. And then after those 7.5 minutes are up for the first student, the second student, also for the respondent, will give their 7.5-minute argument. So after the arguments have completed, the judges are going to give some brief feedback. Then judges will move back to the breakout room and the team and advisor will be dismissed from the hearing room. Okay.
We'll do the comments before we break to do the scoring.
Exactly. Yep.
Oh, okay.
Exactly. All right.
Okay.
Any other questions before we get started?
No, other than we never actually made the Chief Justice decision. I'll be glad to do it. So I guess I'll appoint myself.
Okay. That works very well. All right, so I am going to mute my microphone and hide my video. So Jim Satola, why don't you begin with introductions and we'll take it away.
Okay, my name is Jim Satola. I'm here today from University Heights, Ohio, essentially Cleveland, Ohio, which is kind of near John Carroll University. I have been involved with OCLRE, both mock trial and moot court, for probably close to 15 years, one way or the other, and am on and do the state championship tournaments of both. And I've actually also been on the problem writing committee of this tournament for probably 4 years, all but maybe like the first 2 or 3 years of the program. I'm currently on my own. I was a law clerk to a federal judge, and then with a large law firm for 20 years. And I'm on my own and kind of half the time an Alzheimer's caregiver as well. And I look forward to doing this tournament every year. So I congratulate you both for volunteering to do it this way this year. That's me.
All right, I'll go next. My name is Jedediah Brassman. I'm currently a judicial staff attorney on the 10th District Court of Appeals for Judge Fred Nelson. He recently took over the seat last February. I graduated from Ohio State College of Law in 2017, spent 1.5 years at the Attorney General's office, and then spent the last year with the court. In law school, I participated on the corporate law moot court team and plenty of mock trial teams for both high school, college, and law school. So thanks for doing this. We definitely appreciate the flexibility and looking forward to hearing your arguments.
Hi, my name's Ben Tracy. I graduated from UVA Law School, spent a few years in private practice, clerked for a federal judge, am currently and have been for the past 5 years a staff attorney for the 10th District Court of Appeals. Been working with this program for quite a number of years and wrote the problem the 2 years prior to this. So very glad to see that even in the midst of this pandemic, we are finding a way to make this work, albeit on a limited basis. Thank you very much for participating.
My name's Laura, and I will be arguing the first question today.
The statutory one?
Yes.
Okay, just want to make sure that, because sometimes people switch the order. So the traditional first one, okay.
And I am Sally Hoffman-Curry, and I will be arguing question 2, or the constitutionality question.
Okay.
Could you say your name again? I didn't catch it.
Sally Hoffman-Curry.
Yeah, when you scroll over the person's picture, their name shows up at the bottom of the screen.
My name's Evan Smith. I'm a social studies teacher at Grandview Heights High School and an advisor for the mock trial and moot court teams. We appreciate all your Sally and Lara, both seniors that are kind of getting through this spring through these circumstances, and appreciate the opportunity to do what they love and still compete. So thanks for your time.
Ryan or Kelly, do you do a an opening, or do we just begin?
Nope, we're good to just go ahead and begin.
Okay, we're here to hear oral argument today in case number 20CV9999, State of Buckeye, who is the appellee, versus Julie Jenkins, the appellant defendant here in the Buckeye Supreme Court. And when I believe we are hearing the appellee today argument, am I correct?
We're hearing the appellant argument.
Appellant argument, okay.
Yeah.
Whenever you are ready to begin, Ms. Kowalczyk, you are ready to go.
Thank you, Your Honor. Your Honors, opposing counsel, may it please the court. When the Founding Fathers constructed the Constitution, they established that to protect citizens' liberties, freedom of press and speech is fundamental to the ideas that America was founded on. Today, the fundamental idea of freedom of speech and press are being threatened by Buckeye Code 3517.21. The court system is made to ensure that citizens are granted their undeniable freedoms when civil liberties are being tested. The lower court found Jenkins guilty of 5 prongs in Buckeye Code 3517.21. The first, that her actions occurred during the campaign. The second, that she intended to affect the outcome of the campaign. The third, that she served on the campaign. The fourth, that she served as an agent or employee to the campaign. And the fifth is that she served with the purpose to impede the conduct of the campaign. Today, we are here to demonstrate as to why Jenkins did not violate the second and fourth prong of Buckeye Code 3517.21.
Yeah, I'd like to just ask a preliminary question, if I could. There's actually a second option for the fifth element. It's not only to impede the campaign, but to report on the campaign without the knowledge of the campaign managers, correct?
Yes, yes,
there's
Your
not
Honor.
another method of satisfying that?
Yes, Your Honor. Today, we are only focusing on how Jenkins did not impede the conduct of the campaign, rather than the reporting part of the fifth prong.
Does that mean that you're agreeing that she did report on the campaign?
She did report, yes, she reported on the campaign. However, with this statute, all 5 prongs need to be fulfilled for her to be considered.
Yeah, I guess the question, though, is that fifth prong. I want to let you go to your argument. That fifth prong is in the alternative, meaning that if she did one or the other, that issue is satisfied. So if she did actually report without knowledge, that that probably plays in the constitutional issue, but as to statutory, I mean, that's she admitted to the police that she joined the campaign to do reporting, and then the only fact is whether the campaign knew about it or not.
Yes. She joined the campaign for multiple reasons, but that is part of, she had a nagging feeling
Okay.
So ultimately, I guess to finalize this, are you then agreeing that she violated the fifth prong of the statute?
Yes, we will concede that
Okay.
fact.
Okay. Yeah, 4 to go.
So the first prong that the lower court erred on is that Jenkins was an agent or employee of the campaign. In the case Shalash Inc. versus Liquor Control, it provides a definition of agent, which states a consensuary fiduciary relationship between two persons where the agent has the power to bind the principal by his actions, and the principal has the right to control the actions of the agent. When Jenkins said hello to Reynolds in the conference room, a simple acknowledgement was shared between the two. However, this simple acknowledgement was not sufficient enough to enter a consensual fiduciary relationship, one of trust regarding what was discussed on the phone call that Reynolds made.
Although, didn't Ms. Jenkins have like a script that she needed to follow and times that she needed to make the calls that she had in her normal role as a caller, not necessarily as a conference room person? But didn't the campaign exercise some control over what she did, how she did it? I mean, she wasn't free to just say, hey, you know, I'm going to give free gasoline to everybody that, you know, votes for me.
Of course, the campaign provided a schedule for the volunteers. However, Jenkins found that not everyone was fulfilling their volunteer requirements while she was volunteering with the campaign. And the campaign did not give an explicit script about how to carry the conversation with constituents when she was phone banking, which was a large portion of her volunteer requirements. So of course the campaign expected that their volunteers would call their constituents about things that related to the Reynolds campaign. However, they did not give an explicit script, so therefore they did not control the specific actions of the agent, which is Jenkins and the other volunteers in this case.
Does the fact that she was not paid make a difference in your argument as to whether she was an employee or not?
No, the fact that she was not paid does not constitute any regards to if she was an employee or an agent. It's simply that the campaign was very sloppy in how they handled their volunteers. They did not give them scripts. They didn't even have them report their hours back. And
So your position,
in the
counsel,
same
is that
case,
the level of control was insufficient to constitute an employment relationship. Is that right?
yes. In the case Shalash Inc. versus Liquor Control, again, they defined employee, which states that a person who works in the service of another person under an expressed or implied contract of hire, under which the employer has the right to control the details of work performance. And in this case, work performance can be numbers of hours worked, and the quality of work and what was said during the work. And that was not constituted by the campaign whatsoever. And there's no evidence that there was an expressed or implied contract that was explicit to Jenkins that was given from the campaign. So therefore, Jenkins cannot be considered an agent or employee of the campaign simply because the campaign was very sloppily managed, and they didn't even track the hours, and they didn't even provide a simple script for phone banking, which was a really big portion to the volunteer requirements that most volunteers had to fulfill. The second prong that we are going to disprove today is that Jenkins did not intend to influence the campaign. In today's world, we recognize that causation isn't correlation is not causation. And this was recognized in the Supreme Court case Virginia versus Black. Some people burning crosses have an intent to intimidate. However, the court established that the prima facie provision, because interference alone is clearly insufficient to establish beyond a reasonable doubt that a defendant burned a cross with an intent to intimidate. I would just like to wrap up my final thoughts, if that's okay.
Yeah, certainly.
Jenkins was unsure of what she would learn. She went in with multiple reasons as to why she joined the campaign. Of course, she had a nagging feeling, but that was not completely as to why she joined it, which means that her intent cannot be qualified as an intent to impede or influence the campaign. I would like to give the remainder of my time to my co-counsel, Sally Hoffman-Scurry. Thank you.
Okay, thank you, counsel. And then Ms. Hoffman-Scurry, when you're ready to begin, you may do the same.
Thank you. Your Honor, may I please the court?
I'm having trouble hearing. I can't really hear you.
Okay, am I choppy or is it delayed?
Choppy.
Choppy.
Okay, let me call the number that they gave me. I
Okay.
think my video will be turned off, but my audio should be better.
I can see you, but I can hear you a lot better.
Is this working for everybody?
Yes, actually.
Awesome, okay. I will pick up from the beginning if that works with everyone.
Okay.
Okay. Your Honors, may it please the court. Our democracy is dependent on the existence of the freedom of speech and the freedom of press. The voice of the people is an inherent right. We need our speech to be protected so that we can voice and publish our opinions without fear of punishment. There are exceptions to this rule. However, the speech that Julie Jenkins engaged in was protected speech, and even if the court today falsely concludes that Julie Jenkins was in violation of the Buckeye Code, it is still a violation of the First Amendment rights. Julie Jenkins has aspired to be a journalist her whole high school career. She has a passion for reporting and wants to report on important issues. Throughout high school, Julie Jenkins reported on local government and student politics. But for senior year, she decided to apply for a paid position at Fueling Our Future, which is an online newspaper focused on issues relating to—
Counsel, could I interrupt? You may presume that we are aware of the facts of this case. But what I would like very much to hear you address is you're saying that this is unconstitutional as violative of the speech protections in the First Amendment. But when I look at the statute, I see basically a prohibition on spying, on becoming a mole in a campaign under false pretenses. How is it not just a prohibition on fraudulently obtaining a position with a campaign as opposed to speech?
So the idea that this statute protects the integrity of any campaign is actually incorrect. When you have to hide information from the public, this should be an issue.
Is this really a matter of hiding information from the public? I think it's more of a campaign should be able to have some control as to how it presents its message, perhaps even wanting to save some of the good information for later, closer to the election. And the statute here only doesn't prohibit reporting on a campaign. What it prohibits is gaining an position of inside like access that a normal reporter doesn't have surreptitiously. I mean, isn't it really the conduct that's the issue?
I agree with you that campaigns should have control over the conduct and have some control over their information, but this statute is so overbroad that all of the campaign staff statewide would be affected. The prohibitions and the restrictions are very unclear. There's nothing defined. So really anybody could be in violation of the statute and not know. And this creates a chilling effect on the campaign.
Do a line? Are there, like, let's say the campaign manager or somebody who has real inside access, would it be constitutional as to them? I mean, is your argument that not for a low-level volunteer, but perhaps for a high-level campaign staffer, it might be constitutional?
My argument here is that this statute itself is overbroad and should be subject to strict scrutiny. The interest of protecting the integrity of elections is compelling to the state, but it is not compelling on the First Amendment basis, as well as it is not narrowly tailored to serve this interest. If, for example, the chief of staff were to speak out and there was a more tailored statute, that would be fine. But this statute is just way too overbroad. And
isn't the statute content neutral? I mean, it's focused specifically on a particular type of speech, sure, but it's not focusing on any political party. It's not focusing on, you know, even different campaign promises. It just says information, which yes is broad, but isn't that the point of a content neutral statute?
Right, but within this content, there is content being regulated. So there's content being regulated by class speaker distinction. So candidates are allowed to speak out while journalists are not, or volunteers are not, as well as
journalists, but I see a distinction there, and I apologize for interrupting, but I see a distinction because journalists aren't allowed to get themselves by lying into an organization to then try to spread rumors. Because, for instance, how are we supposed to know, other than what Ms. Jenkins states, is actually what happened? You know, it seems like she's got herself into this and reported this, but if a journalist on the outside wants to contradict, if she wouldn't have done that at all, she would have been allowed to contradict it in her article, right? So the difference is here is that she's impeding the campaign by infiltrating it.
I also think, though, that within this campaign, no one is allowed to speak out without the approval of the candidate. So the effect of this statute is that the content is regulated. A campaign would not approve anything to be published that did not effectively help the campaign or was not good information to the campaign. That is regulating the content of it.
Isn't this also, I want to let you continue, but this statute doesn't say only bad information. I mean, there's a possibility that the campaign may want to hold back good information for strategic reasons. So it isn't necessarily content, is it?
The intent of the statute is not deciding between, hey, you can release this good information but keep this bad information within the campaign. The effect of the statute is that it favors good information over bad information. Any candidate, yes, would not want this published about themselves, so of course they would keep it within the campaign. Also, this statute removes anything within the campaign from public discussion, which is yet again another content-based regulation.
Yeah, you can continue. You'll have some time. We'll give it to you.
So Julie Jenkins began her investigative journalism career when she decided to investigate the claims of Ryan Reynolds, who was the Green Party candidate. He claimed he would transition the entire state of Buckeye to renewable energy by taxing the top 10%. When Julie found out that Reynolds was planning on taxing the top 50% of the state of Buckeye, she went to Twitter and tweeted, "Breaking news, Richard's not telling the truth. More Buckeyes to be hit."
I do have one final question rather than the facts. Is this statute unconstitutional as to everybody? I mean, is it unconstitutional as a matter of fact, or is it unconstitutional? You can answer this question just as it was applied in this case to Julie Jenkins.
It is unconstitutional as a fact, just throughout. You would have to engage in speech to violate this statute, as well as law enforcement or the campaign would have to inquire what you said, how you said it, in order to find you in violation of the statute. And that is a content-based restriction, and it should be held to strict scrutiny, which it then failed.
Okay, thank you, counsel.
Thank you.
I believe that concludes the oral argument. There's no rebuttal here, so I think the case is heard and submitted. Thank you.
Thank you.
Thank you.
Thank you. Feedback now would be great if you have it.
I didn't hear the beginning.
That does indeed conclude the argument portion. Now we can go ahead and move on to feedback.
Oh, okay, okay. I guess I'll start. I thought, thank you for participating. This is it's an interesting way to do it, but I think it works well. You know, we were able to, you know, hear your argument, and sometimes seeing the presentation of the argument helps as well. It's clear that you both understood the case and that you understood the facts and the law as, you know, how it applies to the facts of the case. So I commend you both as to that. And we asked a lot of questions, and some of them were, you know, kind of detailed questions. And I thought you both did a fine job of listening to the question, trying to understand what it was, and to answer that question, you know, as to, you know, individual arguments to Ms. Kowalczyk. You know, you certainly understood that from the factual type of argument, you need to look at each of the elements and address each of the elements, and you don't always necessarily, all you need to go is 1 for 5 to win. So it was good to know that, you know, that you did concede on a couple of the elements, because, you know, she did join a campaign. There's not really any sense in arguing against that. And then the trickier question as to whether she, on the 5th element, joined with the intent of reporting without asking what she was going to say. Because she did. I mean, she admitted to that, you know, and so that's a fact that you may not have come into the room expecting to have to concede, but the understanding that it's fruitful for you to just say, look, I don't need this, and we'll move on. You know, it seems that she did. So, you know, a good understanding of how to understand and argue a factual case. As to Ms. Hoffman-Curry, as to the constitutional, you have a little bit different of a role. It isn't so mathematical as to 5 specific elements here in this case, but more of a broad question of how this law applies for what people have to say. And then you have to ask broader questions as to, does it look at content or it doesn't? Because probably the difference between content and action is your key argument. You understood it, you answered the questions appropriately as to how that works, and did a fine job on that too. So I commend you both for both your participation and your performance today. It was impressive.
Thank you.
Thank you.
I'll go next, I suppose. Thank you very much for participating. These are obviously very unexpected, unforeseen, and atypical circumstances, and it really says a lot about your characters that in your senior year, you've decided to devote some of your free time to doing this, even under these circumstances. So I do thank you for that. It's important to the life of the program, and it says a lot about you personally. I think you both did a very fine job. I do have some constructive feedback for both of you. I agree with what Jim had to say about conceding things. It is a good idea to concede points that you're weak on. That said, I'm not sure I would have conceded on the 5th prong. There is that facet of things where she reports, but when you read the statute, it's reporting to the agent's employer or principal. Seems to me that there's an argument to be made that she wanted to report to the public, not necessarily her employer. And that might well have thrown her out from beyond that element. So, but at the same time, it's also not your strongest argument. So what I think is sometimes not a bad idea to do is to be candid with a court and say, I'm not conceding that. I think there's an argument to be made there, but I have limited time and I want to focus on my stronger points. So if we could, can we put that issue aside and focus on these other elements where I think the state's claim fails? I think that's an okay way to do it. That way you don't concede, but you also don't spend your time talking about something that you're probably going to lose. I also think when you're presenting why the state's claims didn't satisfy certain elements, it's a good idea to give an alternative narrative rather than to set out what the element is and say these facts don't fit it. It's not a bad idea to say what the facts do fit or what sort of facts would fit the statute, and then use that to differentiate. Because, you know, human beings, God bless us, we try, but we're not really abstract creatures. It's nice to be able to draw factual distinctions. But I thought you did a very nice job. For Sally, yeah, I think you had a really difficult task here. I mean, showing that a statute is unconstitutional, wow, that is a tough road to hoe. If you get out there and you look at the case law, statutes do not get found unconstitutional very often. When they do, it's usually as applied. So trying to go for the big facially unconstitutional, in order to do that, you have to show that it's unconstitutional in every application. Boy, that is darn near impossible. That said, you took a shot at it, so hats off to you. You know, that's ambitious. But I think you've got a fair point. I mean, investigative journalism lies at the foundation of this country, and boy, it really seems like that's what Julie was doing. And I think I and most people would have a visceral negative reaction to someone being criminally punished for going undercover and then reporting something publicly. So good job highlighting that. I would say you did kind of recite the facts a couple of times, notwithstanding the fact that I broke in pretty early and told you that the court knew what the facts were. It's not always bad to recite the facts, but if you're going to recite the facts, it ought to be brief and to a specific point, particularly if the court tells you, hey, we know what the facts are. So I hope that helps you if any of you become lawyers. I hope that helps you if you get into business and have to make presentations. It's a good idea to tell people a little bit about what they already know to get them into their comfort zone and then make your point. You know, get in there while they're on the same page with you and make your point. It's not a good idea, though, to do it too much because then they tune out. But wonderful job, both of you, and thank you so much for participating in difficult circumstances.
Thank you.
Thank you.
All right, so I'll finish it up. Once again, I'll reiterate what both the other judges said. I really appreciate the fact that even during all this, you're still doing this. It definitely, as Ben said, says a lot about your character. I'm just going to focus on a few things. I don't want to try to reiterate as like the other judges did, although I will say, Laura, that I agree with Ben. I would not concede that fifth point. One of the things that I thought about too is she actually didn't even publish the article. She said that she stopped that once she's put on Twitter. So I think you have another argument of if the court is going to conclude that it's not just reporting to the supervisor, that it's reporting to the public too, that she didn't report it to the public, that a one sentence tweet is not enough to report. But I also agree with Ben. I think you've got stronger arguments. And if you're going to focus on one of those 5 prongs, I think number 2 is right to focus on. But then I wouldn't even go into the other prongs. You started with number 1 and then moving to number 2. I would just go straight into number 2 because you have a limited amount of time, and trying to get through all 5 of those prongs and explain why those other 4, may have been met or may not. You want to focus on one that you've met. Otherwise, I thought it was a good argument, and I think it's probably the stronger of the 2, just because I again agree with Ben. Very few statutes are found unconstitutional on their face. Although I think there's a decent argument for this one to be made. And then Sally, there was one thing I wanted to point out. You said if this court falsely concludes. The reason I want to focus on that is in this argument, you're talking to the Supreme Court of that state. The Supreme Court doesn't falsely conclude something unless the United States Supreme Court says they have, because you're talking to this court. So I think there's a better way for you to say the same thing without saying falsely concludes. I think just changing it to, even if this court does conclude that Ms. Jenkins did violate the statute, you think they falsely concluded that or incorrectly concluded that, but I think falsely is just putting, it's not a great way to start, in my opinion. And then, I think the same with Ben. If you're going to recite the facts, recite a few facts, and once a judge has told you that they know the facts, you have to assume they know the facts. If they don't, they will ask you, if you can explain various aspects of the facts that they need to know. But again, overall, I think you had the tougher of the argument, but definitely a good try at it. So I appreciate both of your time, and I hope you keep doing this through college.
Thank you.
Thank you.
So what now?
Well, that does conclude the oral arguments round. So let's give the Grandview Heights High School team a round of applause.